Hello friends, welcome back to the series of lecture. This is the sixth lecture of the series of Indian Evidence Act. So in the previous lecture we have left that there are more than one facts in issue has to be proved, and how will you prove that? There we have seen that there are certain facts which together will go on to prove the existence and non-existence of the fact in issue. Now let's talk about the existence only. So all these facts together go on to prove the existence of the fact in issue. Now, out of these facts, suppose there is a party, a plaintiff, and he wants to prove, suppose he wants to prove these seven facts, or if it is a criminal case, then the prosecution wants to prove these seven facts, and the judgment should be based upon only the facts which are relevant and which are duly proved. 165 first proviso. And therefore the court first of all has to see whether these facts are relevant facts or not. Now suppose in this, when the court sees that the facts are relevant or not, court finds that the fact number 1 is relevant fact, fact number 2 is relevant, fact number 5, 6 and 7 are relevant, but fact number 3 and 4 are not relevant fact. Then the court will, as far as the evidence is concerned, the party will give evidences to prove all these facts, and the court will allow or admit the evidences only for those facts which are relevant, and therefore the evidence will be allowed to prove for the fact number 1, 2, 5, 6 and 7. As far as fact number 3 and fact number 4, these the evidences will be not allowed by the court. That is what is called the admissibility of the evidences. Evidence is admissible means what? That evidence is allowed to be proved. Evidence will be admissible only for those facts which are found to be relevant with respect to that particular case. Then after that, once the evidences are allowed, once the evidences are admissible for fact number 1, 2, 5, 6 and 7, then it is the burden upon the party concerned to prove those facts by the evidences. Suppose the party was able to prove the fact number 1, fact number 2 and fact number 7, but is unable to prove the fact number 5 and fact number 6. So fact number 1, 2 and 7, these are the relevant facts which are duly proved. Now as far as the admissibility of the facts are concerned, that means only those facts are taken into the consideration which are relevant and which are being duly proved. Means only those facts will be admissible in order to prove the fact in issue which are relevant and which are duly proved. So that is meant by the admissibility of facts, and before that the admissibility of evidences. So that we had already seen in the previous lecture and write it down also previously. Now continue further. So now we would continue with section 5, 136, 165, proviso 1, 155, then 104 section for this topic. Chapter 2, section 5. Evidence may be given in any suit or proceedings of the existence or non-existence of every fact in issue and of such other facts as hereinafter declared to be relevant and of no others. Evidence may be given in any suit or proceeding of the existence or non-existence of every fact in issue and of such other facts as hereinafter declared to be relevant and of no others. So they are categorically stating that in any trial, किसी भी ट्रायल में, चाहे वो सिविल सूट हो या क्रिमिनल मैटर हो या फिर कोई और प्रोसीडिंग्स हो, उसमें एविडेंस, दे आर सेइंग एविडेंस may be given only of fact in issue and of relevant fact. May be given only of evidence of fact in issue and of relevant fact. So that is a declaratory and a restrictive provisions also. It declares that party can give evidences of what facts. Then number 1 you can give evidence directly for proving the fact in issue and also for proving the relevant facts. And then they are saying and of no others, and of no others. And here the word evidence may be given, word may be is written, evidence may be given. अब इस वर्ड का क्या मतलब हुआ? They are enabling, the party is enabled, the party may give, क्योंकि पार्टी के पास भी डिस्क्रिशन है कि वो एविडेंस देना चाहे या ना देना चाहे. But if the party wants to give the evidence, if the party wants to prove the evidence, then that should only relates to the facts in issue or the relevant facts, and of no others, and of no others. So is it not a directive upon the court or mandate upon the court, kind of directive, that the court shall not admit the evidences if it does not relate it to the fact in issue, does not relate it to the fact in issue or not related to the relevant fact. So ये एक तरीके का declarative provision है, enabling provision for the party, and at the same time it is also a restrictive provision. It restricts the discretion of the court that you can take evidences only of fact in issue or relevant facts and of no others. But you see, this is a general provision. There may be some specific provision. For example, when you read section 165, first paragraph, in the 165 it is clearly provided in the first paragraph that the court can even take evidences of the irrelevant facts. It has to base its judgment on the relevant facts only. Judgment तो हमारा बेस रहेगा on relevant facts. But in 165 para 1, the court is free to take evidence even on irrelevant facts. So this is the special provision, and what we have studied earlier, that is a general provision. Section 5 is a general provision and this one is a special provision. So to that extent the special provision will prevail, but as a general rule, the rule is the parties can give evidences only of the relevant fact or the fact in issue. So in this they are writing, the judge may, in order to discover or to obtain proper proof of relevant facts, ask any question he pleases in the form at any time of any witness or of the parties about any relevant fact, any fact relevant or irrelevant fact, and may order production of any document or thing. So they are talking about of any witness or of the parties about any fact relevant or irrelevant. So I make a correction here. They are not talking about recording of evidences directly. Rather, they are talking about asking questions related to irrelevant facts also. But obviously, when the court puts the question, it becomes the part of record. क्योंकि जो भी कोर्ट पूछेगा आप जवाब दोगे वो लिखा जाएगा. So in that way 165 para 1, 165 को डिटेल में हम बाद में पढ़ेंगे. But as for here now, 165 enables the court to ask questions and to record that related to even irrelevant facts. जबकि section 5 क्या कह रहा है हमारा? Evidence may be given only of relevant facts and fact in issue. So you can say that section 165 is little bit different from section 5, which enables the court to ask any questions even for irrelevant facts. This is a special provision and section 5 is a general provision. So to that extent the special provision will prevail. Now इसी तरीके से एक और section है, section 155. In this section they are talking about the witness, the credit of a witness. may be impeached in the following ways by the adverse party. The credit of witness may be impeached in the following ways by the adverse party, or with the consent of the court by the party who calls him, by the evidence of persons who testify that they, from their knowledge of the witness, believe him to be unworthy of credit, and by proof that the witness has been bribed, by proof of the former statement inconsistent with any part of his evidence which is liable to be contradicted. अब इतनी डिटेल में नहीं जाना आपको. The point which we have to look with this topic is this much, that in section 155 it is allowed that the party concerned can give evidences to discredit the witness, that he has taken bribe, or there are people who believe that the witness is unworthy of credit. अब note it that witness की जो credit है, या witness की credibility, उस केस में कोई relevant fact नहीं हो सकता. अब suppose कोई केस चल रहा है, उसमें मैं witness बनकर बयान देने जाता हूँ. अब वहाँ पर अपोजिट पार्टी मेरी क्रेडिट को इम्पीच करने के लिए अपोजिट पार्टी मेरे खिलाफ कुछ एविडेंसेस देता है. अब मेरा कैरेक्टर या मेरी क्रेडिबिलिटी उस केस में ना तो फैक्ट इन इशू है, बिकॉज आई एम जस्ट ए विटनेस. सो माई क्रेडिबिलिटी, वेदर आई हैव टेकन ब्राइब और नॉट एक्सेट्रा, is neither a fact in issue in the suit or proceeding, nor it is a relevant fact. Still such a evidence is allowed to be proved. अब हमारा सेक्शन 5 क्या कहता है, that you can give only evidences only of fact in issue and relevant facts, but the credit of witness is not a fact in issue or a relevant fact. Still section 155 allows that, enables to hence the reliability of that particular witness. So this is also a special provision. So section 155 will also applicable despite the mandate of section 5, because section 5 tells you that you may give evidences of relevant facts or facts in issue and of no other facts. But we have just shown that in 165 first para the court has the discretion to ask questions of irrelevant facts, though the proviso makes it clear that the judgment should be based upon only on relevant facts, and that too if it is duly proved. Then the second thing is the 155. As per section 155, the evidence may be given to discredit or impeach the credit of the witness, because the credibility of the witness as such is not the relevant fact, nor it is an fact in issue. It may be called indirectly relevant fact, but directly it is not relevant or fact in issue in that case. Still, the evidence to impeach the credibility of witness is allowed. And the third thing you need to know is the evidence may be given for the relevant fact or fact in issue. Means what? The party has the right to give evidences on any relevant fact or fact in issue. Means the party has the right to give evidences on any facts which is a fact in issue or relevant fact, but there are some prohibitive sections which disables the party to give evidence. For example, the case which is fall under the privileged communication, section 121 till 131. There the communications we are talking about, that may be a relevant fact in a particular case, but since it is privileged, the evidence are not allowed to be given. If the husband says something to the wife, and in a suit with respect to someone, what did the husband say to the wife? That statement cannot be proved. Even if it is a relevant fact or directly a fact in issue, that statement cannot be allowed to be proved into the case. That is the illustration. We are discussing here in the very elementary terms, not discussing in details. Similarly, when you talk about the section 25 and 26 of the Evidence Act, Section 25 says that if a confession is made to a police officer, that shall not be allowed to be proved. And 26 says that if the confession is made while in police custody, excepting the immediate presence of the magistrate, the confession will not be allowed to be proved. अब confession made to a person is a relevant fact. जब भी आप कोई confession करते हो that is a relevant fact. फिर भी अगर वो पुलिस ऑफिसर को दिया था या पुलिस कस्टडी में दिया था तो उसका प्रूफ अलाउड नहीं होगा. So what I am trying to tell you is that there are some restrictive provisions in the Indian Evidence Act which declares that despite the fact is a relevant fact, the evidence will not be allowed to be proved. And similarly, there are some sections, enabling sections in the Indian Evidence Act, which declares that dis- despite the fact that the fact not being a relevant fact, evidence may be allowed to be proved. So both the things you have to keep into mind. And section 5 is a general provision, and when the specific provision is read out over the general provision, then to that extent that specific section will prevail. Otherwise the general rule is laid down in section 5. अब एक क्वेश्चन अरोज होता है, द कन्फेशन मेड टू ए पुलिस ऑफिसर इज रेलिवेंट. सेक्शन 25-26 में, अब सेक्शन 25 में कन्फेशन मेड टू ए पुलिस ऑफिसर इज ऑलवेज रेलिवेंट, बट द एडमिसिबिलिटी ऑफ दैट एविडेंस इज नॉट अलाउड. सवाल ये है कि रेलिवेंट तो है लेकिन इसको प्रोहिबिट कर दिया. अब या तो ये बता दो कि इसको प्रोहिबिट क्यों कर दिया, और या फिर ये बता दो कि जो प्रोहिबिटेड है वो रेलिवेंट कैसे हो सकता है. अब देखिए, इट इज़ रेलिवेंट. कन्फेशन मेड टू यू मी, इट इज़ रेलिवेंट बिकॉज कन्फेशन इज द एडमिशन ऑफ गिल्ट, सो दैट इज़ रेलिवेंट ऑलवेज. जब आप 21 में जाओगे तो कन्फेशन की रेलिवेंसी 21 में, एनी एडमिशन और फैक्ट विच कैन बी प्रूव्ड अगेंस्ट यू in the trial be always relevant. Any admission of fact which goes against the party or person is always relevant. And confession is also admission of fact against that person, so that can always be proved against him, and that is relevant. But since it is made to the police officer, so the element of fear is always be suggestive when he make the statement. Even if it does not falls in section 24, it smells some kind of threat or fear, and therefore as a matter of policy it will declare not to be allowed to be proved. So relevant है कि नहीं वो अलग बात है, but allowed होगा प्रूव करने के लिए कि नहीं वो अलग बात है. अब बहुत रेयर केस में उन्होंने प्रोहिबिट कर रखा है. Confession made to police custody, confession made to police officer, there is no doubt they are relevant. But the policy is that there is always fear element. There may be fear element, so it will not be allowed to be proved. Similarly, suppose a person makes communication to his wife, and the husband told to his wife that he saw X killing Y. Now tomorrow X is tried for the murder of Y, and suppose the wife of the husband goes there and give evidence that my husband has said. अब यहाँ पर ये हियर से है ऑब्वियसली. अब वो इस बात का एविडेंस तो दे नहीं सकती कि एक्स ने वाई को मारा डायरेक्टली. इस बात का एविडेंस है कि मेरे हस्बैंड ने मुझको ऐसा कहा था. उस चीज़ का एविडेंस दे सकती है कि मेरे हस्बैंड ने मुझको क्या कहा था. सो दैट विल बी रेलिवेंट, बट दैट विल नॉट बी अलाउड टू बी प्रूव because that is the private communication between the husband and wife. Similarly, in the case of vice versa, means if the wife said to husband, then husband is not allowed to be proved, even though it was relevant. What was the logic? The logic behind is that the husband and wife refrain to communicate each other if they are allowed, or their communication is allowed to be proved as evidence in some case. And if the communication is refrained due to some reason, the marital relation between husband and wife get spoiled, because every relationship is depends upon the communication. So husband and wife would not allowed to be give evidence unless there is a suit or proceedings between the husband and wife directly. So कोई भी चीज रेलिवेंट है या डायरेक्ट इफेक्ट इन इशू का एविडेंस हो सकता है वो, लेकिन वो एज ए मैटर ऑफ पॉलिसी अलाउड नहीं होगा। सो क्वेश्चन ये था, जो बात प्रोहिबिटेड है वो रेलिवेंट कैसे होगा। अब इस चीज को हम उल्टा अगर सोचें कि जो रेलिवेंट है वो रेलिवेंट है, वो प्रोहिबिटेड नहीं होना चाहिए। जो चीज रेलिवेंट है वो तो रहेगी रेलिवेंट, वो बट वो प्रोहिबिटेड नहीं रहना चाहिए। लेकिन वो प्रोहिबिटेड कुछ केसेस में रहेगा यहाँ पर मैटर ऑफ पब्लिक पॉलिसी इन्वॉल्व होगी। सो राइट डाउन, सेक्शन 5 enables a party to prove evidences of relevant facts or fact in issue. It is restrictive as it declares that apart from the above, evidence cannot be given of any other fact. The word may be, inverted commas में, the word may be has used in this section clearly enables the party to give evidences as aforesaid. A plain reading of the section would suggest, number 1, that the party may give evidence of the any relevant fact or fact in issue. Number 2, that if the fact is not relevant or fact in issue, if the fact is not relevant or fact is not a fact in issue, then evidence of it cannot be given. Next paragraph. However, there are provisions, for instance, section 25 and 26, section 121 till 131, privileged communication, which disallow the proof of evidences, even though the fact is a relevant fact. Similarly, section 56 till 58, याद करो 56, 58 till 58, judicially admitted fact or judicially admissible fact and judicial admitted fact. The facts which are admitted in the pleadings and judicial noticeable facts. These are in 56 till 58. So similarly, section 56 till 58 clearly enable the party to not to give evidence of the facts which are judicially noticeable facts or facts which have been admitted in pleadings. So basically the point is that कि ये जो सेक्शन 5 जैसा लिखा है वैसे स्ट्रेटली एप्लीकेबल नहीं होगा। देयर आर स्पेशल प्रोविजंस विच अलाउ एविडेंसेस फॉर irrelevant facts also, and there are provisions or sections which disallow evidences for relevant facts also, and there are also sections which do not allow or disallow but which declares clearly that evidences on those facts need not to be proved. सेक्शन 56 टिल 58 वही तो है कि अगर कोई जुडिशियल नोटिसेबल फैक्ट है या फिर एडमिटेड फैक्ट इन प्लीडिंग है या जुडिशियल नोटिसेबल फैक्ट है, तो उसमें आपको एविडेंस देने की जरूरत नहीं पड़ेगी। Similarly, there are certain provisions which allow the proof of evidences or allow questions even if the fact concerned is not a relevant fact. In section 155 and 165, the court can ask question even on irrelevant facts. 165 में कर सकती है क्वेश्चन आस्क कर सकती है इवन ऑन द रेलिवेंट फैक्ट। तो सेक्शन 155 में टू इम्पीच द विटनेस कर सकते हैं, फैक्ट एविडेंस को अलाउ कर सकते हैं, एंड इन सेक्शन 165 द कोर्ट कैन आस्क क्वेश्चन इवन ऑन द रेलिवेंट फैक्ट्स। नाउ लेट्स सी द एक्सप्लेनेशन ऑफ सेक्शन 5। This section shall not enable any person to give evidence. This section shall not enable any person to give evidence of a fact which he is disentitled, to prove by any provision of the law for the time being in force relating to civil procedure code. So that is a very simple thing. On one hand, they are saying that the evidence may be given. Means what? Means suppose I am a party. If I am party, so by this section I am entitled of any fact in issue or relevant fact, but of section 25, 26 and privileged communication etc. I will not. Even though that is not mentioned here, but that is more specific. That are prohibitive provisions and this is general provision 25, 26, 121 till 131. So those provisions will prevail and those evidence cannot be given. Similarly, if there is some other restrictions given in CPC, अगर CPC में कहीं लिखा है कि the evidence of such and such fact cannot be given by you, then despite it is an enabling provisions of section 5, then that particular provision of CPC will prevail. So सिंपल सा लॉजिक है, सेक्शन 5 आपको एनेबल कर रहा है कि आप एविडेंस दे सकते हो फैक्ट इन इशू और रिलेवेंट फैक्ट्स पर, लेकिन यहाँ जहाँ स्पेसिफिक प्रोविजंस है जो प्रोवाइड कर रहे हैं, फॉर एग्जांपल 25, 26 प्रिवेल करेगा कि नहीं, 121 till 131 also prevail. So similarly, if there are some provisions in the CPC and which declares that in such and such circumstance the party will not be allowed to give so and so evidence, then that provision will prevail. So that is what they are intending the writing. जैसे 25, 26 etc. will prevail, ऐसी CPC will prevail. So read it again. This section shall not enable any person to give evidence of a fact which he is entitled to prove by any provisions of the law for the time being in force relating to CPC. So CPC से related किसी provision में अगर prohibition है, then you will not be allowed to give the evidences. And some of the provisions of CPC I am dictating to you. Please note down. One is Order 8, Rule 1A. Then Order 7, Rule 14. Order 7, Rule 14 में क्या है? That along with the copy of the plaint, you have to file the list of document. Copy of plaint के साथ आपको list of document file करना पड़ेगा, upon which you are relied in the trial. And if you do not have it, you have to specify to the court as where it is, so that the court can issue summons to get the documents in the trial. And if you do not write the name of the document into the list, then in the trial stage, if you want to use that particular document in evidence, then it will not be allowed per se unless the court gives the permission. मतलब अगर कोर्ट ने परमिशन नहीं दिया तो बेशक वो डॉक्यूमेंट किसी रेलिवेंट फैक्ट पे है, उसको आप प्रूफ नहीं कर सकते. सिमिलरली ऑर्डर 8 रूल 1 इज अबाउट द रिटन स्टेटमेंट. उसी तरीके से ऑर्डर 13 रूल 1, देन ऑर्डर 41 रूल 27. So these are some provisions in the CPC which are prohibitive of furnishing of some documents. So even if the documents are upon of some relevant fact, if it falls under this provisions of the CPC, then that document will not be allowed to be proved. जैसे 25, 26 मना कर रहा है, 121, 131 is prohibiting privileged communication, वैसे ही इसमें भी है CPC में, they are also prohibiting. ये जितने भी हैं CPC में, these are the special provisions and prevail upon the general provision of Section 5 of Indian Evidence Act. Now let's see the illustration. A tried for the murder of B by beating him with a club with the intention of causing his death. At A's trial, the following facts are in issue. A's beating B with the club. A's causing B's death by such beating. A's intention to cause B's death. अब बताइए इन सब फैक्ट्स पर एविडेंस अलाउड होगा कि नहीं? Yes, it may be allowed. These are the facts in issue and they may all be allowed to be proved. So in सब पे the evidence is permissible. Then clause B, a suitor does not bring with him and have it in readiness for production at the first hearing of the case a bond on which he relies. This section does not enable him to produce the bond or prove its contents at a subsequent stage of the proceedings, otherwise than in accordance with the conditions prescribed by the CPC. So illustration B ये बोलता है कि अगर फर्स्ट हियरिंग पे आपको प्लेंट की कॉपी के साथ बॉन्ड की कॉपी भी लगानी चाहिए थी और फर्स्ट हियरिंग पे भी आप अगर बॉन्ड की कॉपी नहीं लाए तो बाद में क्या बॉन्ड की कॉपी आप अपनी मर्जी से प्रोड्यूस कर दोगे? आंसर इज नो. ऑर्डर 7 रूल 14 clearly says that unless the court permits, you cannot use a document. So yes, second illustration is that is related to the explanation. The suitor does not bring with him and have in readiness for the production at the first hearing of the case a bond on which he relies. This section does not enable him to produce the bond or prove its contents at a subsequent stage of the proceedings, otherwise than in accordance with the condition prescribed by the Code of Civil Procedure CPC. और ये जो फर्स्ट इलस्ट्रेशन है दैट इज सीम्स टू बी हाफ वर्डेड. इसमें ठीक से लिखा नहीं है बट इसका मतलब है दैट कि ये जो भी फैक्ट्स हैं ये सब फैक्ट्स इन इशू हैं और इन सब पर एविडेंस अलाउड होगा. नाउ यू मूव इनटू 136 पैरा 1 आफ्टर दिस. सेक्शन 136 पैरा 1. देखिए जब भी ट्रायल में कोई पार्टी कहती है, ट्रायल चल रही है उसमें कोई पार्टी कहती है मुझको ये एविडेंस प्रोड्यूस करना है, तो कोर्ट हमेशा अलर्ट होगा कि इस एविडेंस से पार्टी कौन सा फैक्ट प्रूव करने वाली है. तो पार्टी बताएगी कि मैं ये फैक्ट प्रूव करने वाला हूँ. फिर कोर्ट इस बात पर भी अलर्ट होगा कि इस केस में ये फैक्ट इन इशू है या रेलिवेंट फैक्ट है कि नहीं. अगर उस केस में वो फैक्ट इन इशू या रेलिवेंट फैक्ट है तभी कोर्ट उसमें उस एविडेंस को अलाउ करेगी, अन्यथा नहीं करेगी. क्योंकि अभी तक जो आपने पढ़ा इन सेक्शन 5 and 165 फर्स्ट प्रोवाइजो, what we come across now is that if party wants, he can get evidence only for proving fact in issue or relevant fact. In rare cases, you can give evidences for the facts like impeaching the credit of the witnesses or 165. Otherwise, everywhere he has to give evidence only for proving the fact in issue or relevant fact. So the court may always ask him, suppose I am the plaintiff and in the trial I said that I want to call Mr. X as a witness. Then the court may always ask me that on what facts you want to call Mr. X, on what facts you give the evidence. Then I will say of so and so fact. Suppose in a criminal case, Santosh Singh का case remember करो. Suppose I say that I want to prove that he has a cup of coffee in the canteen in the morning of that day. Then the court can ask that he is having the coffee, how it is relevant. Then the prosecution would say that there is another fact which is relevant. The fact that he is having the visor upon the helmet and in the law faculty canteen he was present, means in the morning he was present, and there is another witness who gave the evidence that the helmet has a visor. So the evidence of this canteen wala corroborate the fact that actually the other person is not lying, because his evidence is going on to prove that Santosh Singh was present in the law faculty canteen in the morning that day. अब इस एग्जाम्पल को थोड़ा घुमा दिया है. वैसे डायरेक्टली भी I can directly call the Mr. X. Then the court asks for what? To prove the fact that the helmet is having the visor in the morning. And if the court asks, then I will tell the court that how it is relevant. that a helmet is having the visor in the morning and in evening it was not, and at the scene of the crime a lot of pieces of the visor were found, and when asked he has lied to the police. So in that way he is having the visor in the morning, it becomes the relevant fact. Then the court will allow me to call that witness or to prove the evidence. अब हर पॉइंट पे हर केस में नहीं पूछेगा कोर्ट, क्योंकि ज़्यादातर केसेस में कोर्ट को दिख जाता है कि कौन सा फैक्ट रेलिवेंट है, इसलिए हर बात पर कोर्ट सवाल नहीं पूछेगी। कई बार अपोजिट पार्टी ऑब्जेक्शन भी लगा देती है दैट दिस फैक्ट इज़ नॉट रेलिवेंट, या फिर कोर्ट सुओ मोटो भी ऑब्जेक्शन लगा सकता है, प्रूव्स दैट कि दिस फैक्ट इज़ रेलिवेंट, बट द कोर्ट वुड डू रेयरली out of 100 evidences in 2 or 3, but otherwise always in a routine matter court knows what is relevant and what is not relevant, but still in some cases court may object or the party may object, and then the role of 136 came. अब 136 का जो philosophy है या principle है that is in 165 proviso and in section 5, जो अभी तक आपने पढ़ा 165 और 5 में, उसी का manifestation आपको 136 में मिलेगा। So read it. When either party proposes to give evidence of any fact, the judge may ask the party proposing to give the evidence in what manner the alleged fact, if proved, would be relevant, and the judge shall admit the evidence if he thinks that the fact, if proved, would be relevant and not otherwise. This is what called the admissibility of evidence. देखो जो admissibility of evidence का जो principle है that is in section 5 and section 165, लेकिन admissibility of evidence का proceedings होगा that is provided in section 136. proceedings दे रखा है 136 में, and the judge may allow the evidence to be proved only if he is satisfied that the fact is a relevant fact. और उसका basis कहाँ है? The court shall decide the case only on the basis of relevant fact duly proved. Read it again. When either party proposes to give evidence of any fact, the judge may ask the party proposing to give the evidence in what manner the alleged fact, if proved, would be relevant, and the judge shall admit the evidence if he thinks that the fact, if proved, would be relevant and not otherwise. So कभी आप एविडेंस देना चाहते हो किसी बात का, तो जज आपसे पूछ सकता है कि ये कैसे रेलिवेंट होगा, और अगर जज सेटिस्फाई हो जाए कि ये फैक्ट रेलिवेंट है तब वो उस पर एविडेंस अलाउ करेगा। इसके लिए आप सेक्शन 104 भी एक बार पढ़ लो। द बर्डन ऑफ प्रूविंग एनी फैक्ट नेसेसरी टू बी प्रूव्ड इन ऑर्डर टू एनेबल एनी पर्सन टू गिव एविडेंस ऑफ एनी अदर फैक्ट इज ऑन द पर्सन हु विशेस टू गिव सच एविडेंस। एक्चुअली ये जो सेक्शन 104 है ये 1 से इतना रिलेटेड नहीं है 136 पार्ट 1 से, जितना ये 136 के पार्ट 2 और 3 से रिलेटेड है। द बर्डन ऑफ प्रूविंग एनी फैक्ट नेसेसरी टू बी प्रूव्ड इन ऑर्डर टू एनेबल एनी पर्सन टू गिव एविडेंस ऑफ एनी अदर फैक्ट इज ऑन द पर्सन हु विशेस टू गिव सच एविडेंस। मतलब अगर मैं किसी एक फैक्ट पर एविडेंस देना चाहता हूँ, कोर्ट मुझसे पूछता है कि ये फैक्ट कैसे रेलिवेंट होगा, तो मुझे अगर उस फैक्ट की रेलिवेंसी प्रूव करने के लिए कोई और फैक्ट अगर प्रूव करना पड़े तो उसका बर्डन किस पे होगा? आई विल हैव दैट बर्डन। इफ आई वांट टू प्रूव ए पर्टिकुलर एविडेंस एंड कोर्ट आस्क मी एज हाउ इज दैट फैक्ट इज रेलिवेंट, and I can prove the relevancy of that fact only by proving some other fact, then I must first prove that other fact, and then only the relevancy will prove, and then the evidence will be allowed. And who is having the burden of proving that fact? The party who proposes to give the evidence. Illustration देख लेते हैं। A wishes to prove a dying declaration by B. अब डाइंग डिक्लेरेशन तो तभी रेलिवेंट होगा जब डाइंग डिक्लेरेशन करने वाला मर गया हो। Suppose B makes a dying declaration and B thereafter does not die, then how it is a dying declaration? Dying declaration का मतलब ये है कि dying declaration करने वाला मर गया हो. अब the court may ask you how this statement is relevant. Then you say it is a dying declaration. Then the court may require to prove that the person who made this declaration is dead. The person who made this declaration is dead. A wishes to prove a dying declaration by B. B ने कोई dying declaration दिया. ये कहता है कि मैं इस स्टेटमेंट को प्रूव करना चाहता हूँ. कोर्ट कहती है कि क्यों प्रूव, किस वजह से ये रेलिवेंट है. वो कहता है डाइंग डिक्लेरेशन है. तो कोर्ट पूछेगी पहले ये प्रूव करो कि बी मर गया है, तभी तो रेलिवेंट होगा डाइंग डिक्लेरेशन. A wishes to prove a dying declaration by B. A must prove B's death. Similarly, A wishes to prove by secondary evidence the contents of a lost document. अब जब भी आपके पास कोई ओरिजिनल डॉक्यूमेंट होगा, अब सपोज ए पर्सन इज हैविंग ए ओरिजिनल डॉक्यूमेंट, वो उससे खो जाते हैं एंड ही इज हैविंग फोटो कॉपी ऑफ दैट ओरिजिनल डॉक्यूमेंट. अब जो नॉर्मल रूल है वो आपको ये है कि आपको ओरिजिनल डॉक्यूमेंट प्रोड्यूस करना पड़ेगा. अब सपोज पर्सन लॉस्ट दैट डॉक्यूमेंट, ओरिजिनल डॉक्यूमेंट, देन दैट person will seek the permission from the court that allow me to provide the Xerox copy of document, lost document. Then the court will allow me the Xerox copy only when I prove that the original has been lost. Otherwise, secondary evidence, the Xerox copy will not be allowed. That is what they are saying here. A wishes to prove by secondary evidence the contents of a lost document. A must prove that the document has been lost. अगर document lost नहीं हुआ है, then the secondary evidence will not be allowed. So basically, if you want to give the evidence in the trial, then that evidence would be on a fact. Then that fact has to be a relevant fact or directly affect an issue. And now, if the relevancy of that fact is doubted by the court, then who is having the burden to prove that that fact is relevant? The party who proposes to give the evidence. And if the relevancy of that fact is dependent upon the proof of some other fact existing, then that other fact has to be proved by the party first, and then only the evidence would be allowed on that relevant fact. जैसे आपको अगर किसी का डाइंग डिक्लेरेशन प्रूव करना है, तो पहले ये प्रूव करो कि वो मर गया है. कहीं अगर वो जिंदा हुआ तो तब तो वो डिक्लेरेशन डाइंग डिक्लेरेशन नहीं होगा. सो दैट इज व्हाट इज इन 104. 104 is upon the burden of proof, and 136 is about admissibility. एक बार फिर से 136 का फर्स्ट पैरा देखते हैं, and please note down all these points. When either party proposes to give evidence of any fact, the judge may ask the party proposing to give the evidence in what manner the alleged fact, if proved, would be relevant, and the judge shall admit the evidence if he thinks that the fact, if proved, would be relevant and not otherwise. And the judge shall admit the evidence if he thinks that the fact is, if proved, would be relevant. Now let's see the second paragraph. If the fact proposed to be proved is one of which evidence is admissible only upon proof of some other fact, such last mentioned fact must be proved before evidence is given of the fact first mentioned, unless the party undertakes to give proof of such fact and the court is satisfied with such undertaking. अब जो 104 का जो फर्स्ट इलिस्ट्रेशन है वो इधर अप्लाई हो जाएगा। इफ द पार्टी वांट्स टू प्रूव अ डाइंग डिक्लेरेशन, इलिस्ट्रेशन में था इफ द पार्टी वांट्स टू प्रूव द डाइंग डिक्लेरेशन, so when the party wants to prove the dying declaration, then obviously the court may ask him that as to how it is a dying declaration. Then the party has to first prove the person who have made this declaration is dead, or he may give an undertaking that let me prove the dying declaration first, later on I will prove that the person is dead. And if the court is satisfied with the undertaking, then it may allow to prove the dying declaration first. Later on, it will allow to prove, later on he can give evidence to prove that the person is dead. But normally in these cases the court will be rigid. If there is no proof the person is dead, the court may be rigid. The court will be rigid and they will require to prove the death of a person first, and only then the declaration will be allowed. अब इसके लिए हम पढ़ते हैं 32 क्लाउज 4। 32 क्लाउज 4 पढ़ने के लिए मेन पैरा पहला पढ़ना पड़ेगा, क्योंकि 32 के जो सारे क्लाउजेज हैं वो अदर सेक्शंस के साथ हम धीरे धीरे पढ़ेंगे। तो इसके साथ हम पढ़ते हैं 32 क्लाउज 4। हम किसी भी क्लाउज को पिक कर सकते हैं वैसे इसके साथ, बट हम क्लाउज 4 को पढ़ते हैं इसमें। फॉर नाउ टेक आउट सेक्शन 32। तो इसके लिए पहले फर्स्ट पैरा पढ़ते हैं। स्टेटमेंट्स रिटन और वर्बल of relevant facts made by a person who is dead or who cannot be found or who has become incapable of giving evidence or whose attendance cannot be procured without an amount of delay or expenses which under the circumstances of the case appears to the court unreasonable are themselves relevant fact in the following cases. So the person whose statements we are talking is dead, either he is dead or he is missing or cannot be brought to the court. Statements written or verbal of relevant facts made by a person who is dead or who cannot be found, missing, or who has become incapable, who is incapable of giving evidence, or whose attendance cannot be produced without an amount of delay or expense, and that amount of delay or expense under the circumstance of the case appears to the court. कोर्ट को ये appear लगती है कि that delay or expense is unreasonable are themselves relevant fact in the following case. Now let's take an example. मान लीजिए किसी विलेज में एक तालाब है और वो किसी पर्टिकुलर फैमिली से बिलोंग करता है, दैट इज नॉट अ गवर्नमेंट पॉन्ड एंड इट इज बिलोंग टू ए प्राइवेट फैमिली। अब उस पॉन्ड में क्योंकि एक फैमिली से बिलोंग करता है वो, और काफ़ी समय से, मान लो कोई बच्चा इस टाइम है और उसके दादाजी के टाइम से वो उस पॉन्ड को, जो गांव के लोग हैं फॉर बाथिंग पर्पजेज, फॉर एग्रीकल्चर पर्पजेज एंड अदर पर्पजेज, उस पॉन्ड के पानी को यूज़ करते हैं हुए आ रहे हैं। सो ये प्रैक्टिस उसके दादाजी के टाइम से चली हुई आ रही है। अब सपोज कोई व्यक्ति उस गांव में 98 ईयर्स का है। अब दिस 98 ईयर ओल्ड मैन मेक्स अ स्टेटमेंट टुडे कि उस तालाब में गांव वालों का भी अधिकार है कि वहाँ से पानी ले सकें। अगर बारिश नहीं होती है तो दे विल टेक द वाटर फ्रॉम द पॉन्ड फॉर द इरिगेशन पर्पजेज। सो दैट इज बिकम्स द कस्टमरी प्रैक्टिस। अब वो इतना वृद्ध व्यक्ति है उस गांव का, ही मेड ए डिक्लेरेशन मे बी इन राइटिंग और मे बी ओरली समवेयर that from so and so pond the people is having the customary right to take the water from the pond. अब सपोज ए सेड दैट इस तालाब से मैं किसी को पानी नहीं देने दूंगा क्योंकि ये मेरी फैमिली से बिलोंग करता है, मेरी फैमिली का है, मेरा है, एंड आई विल नॉट अलाउ टू टेक वाटर फ्रॉम दिस। अब द पॉन्ड वाज मेड बाय एज दादा और परदादा, सो व्हेन ही डज नॉट अपोज हिज दादा और परदादा, and till date his father or uncle was not opposed, So now that customary right is already established. Now the question is to prove whether that customary right is established or not. Now for that purpose, if that old man is alive, he can be taken to the court. तो तब तो 32 लगाने की जरूरत नहीं पड़ेगी, because 32 में the person should be dead or missing or etc. If he was alive, he is alive, then he can taken to the court and he give a statement. But suppose he is dead or missing or incapable, then in that case, if he is dead, the statement that he has made earlier was a spontaneous statement, and that was made by him before any controversy arrived on the pond, means that a statement was made by him in the normal course of events, and he was the person who could have told the court that the pond is having the customary right, but he is dead, but his statement can be proved in the court. उसका जो स्टेटमेंट है जिसके भी सामने दिया था या लिखा था वो कोर्ट में प्रूव किया जा सकता है. As to so and so person made the so and so statement regarding the existence of the customary right, and he would have been likely to aware, because he is such an old person living in the same village, so he would be likely to aware of the existing of the customs, and he had made the statement about the controversy that has arises. So it is not a biased statement, it was a spontaneous normal statement before the controversy. अब यहाँ पर suppose I propose into the court to prove the statement of that old person that I want to call the so and so person, to prove that what so and so person has said earlier. Then the court will ask me that how it is relevant. Then I will argue into the court that in 32 clause 4 it was relevant. Then the court can ask me that 32 clause 4 only allows if he is dead or missing etc. Then you first prove that he is dead. जैसे डाइंग डिक्लेरेशन देते हो वैसे ही यहाँ पर है. You have to first prove that he is dead. Therefore I have to prove first that he is dead. Then only that evidence will be allowed. Or I can give the undertaking to the court that in undertaking that I promise hereby that I will prove that fact later on. Let me prove the statement first. मैंने प्रॉमिस किया है कि मैं बाद में प्रूव कर दूंगा डेथ, पहले मुझे स्टेटमेंट प्रूव करने दो. एंड द कोर्ट मे अलाउ. Normally the court is rigid in such cases to prove first the death. So read 4 clause. Statement written or verbal or relevant facts made by a person who is dead gives opinion to public right or customs or matters of general interest when the statement gives the opinion of any such person as to the existence of any public right or custom or matter of public or general interest, of the existence of which, if it existed, he would have been likely to be aware, and when such a statement was made before any controversy. When such a statement was made before any controversy as to such right, customs or matter had arisen. अब यहीं पर आपका 104 लग जाएगा. If the relevancy of one fact depends on some other fact, and here the relevancy of that statement depends upon what? Relevancy of the statement of that old man under 32 clause 4 will depends upon what? That he is dead or missing etc. today or unable. So first of all I have to prove that he is dead. अब dead होना इस केस में important नहीं है इसका. इस व्यक्ति का डेड होना इस केस के लिए रेलिवेंट फैक्ट और फैक्ट इन इशू नहीं है, लेकिन उसका डेड होना उसके स्टेटमेंट को 32 क्लास 4 में रेलिवेंट बना देगा. एंड देयरफॉर आई विल बी रिक्वायर्ड टू प्रूव हिज डेथ फर्स्ट, एंड देन ओनली आई विल बी रिक्वायर्ड टू प्रूव हिज स्टेटमेंट. एंड सिमिलरली इन द केस ऑफ डाइंग डिक्लेरेशन, और डाइंग डिक्लेरेशन भी 32 क्लास 1 में फॉल करेगा. अब वैसे एग्जाम्पल हम इसमें से किसी भी क्लाउज को उठाकर ले सकते थे, बट For now we have seen clause 4 only. Now come again on 136. So write down first on 136. Section 136 is based upon the principles laid down in Section 5 and Section 165 proviso. Section 136 clearly enables the court to require the party to prove first as to the fact that he seeks to prove the evidence is a relevant fact. Unless the relevancy of the fact is proved, evidence of that fact will not be allowed or admissible. Will not be admissible. Next paragraph. In some cases, the relevancy of the fact would depend upon the existence of some other fact, and in such cases, as per section 104, the burden lies upon the party proposing to prove the fact to first prove that other fact upon which the relevancy is dependent. For example, in case the section 32 clause 4, in the case of the section 32 clause 4, the party has the burden of first proving the fact that the person who made the statement is dead or is missing, and then only he will be allowed to prove the statement made by such person as per section 136 para 2. As per section 136 para 2. However, the party may give undertaking to the court to prove that other fact. What other fact? Of death. Other fact of death subsequently, and the court may allow the undertaking. उस केस में आपको स्टेटमेंट पहले प्रूव करने दिया जाएगा और डेथ आप बाद में प्रूव करना. नाउ लेट्स सी द इलस्ट्रेशन ए ऑफ 136. ये वही एग्जांपल है मैंने आपको बताया था. इट proposed to prove a statement about a relevant fact by a person alleged to be dead, which statement is relevant under section 32. The fact that the person is dead must be proved by the person proposing to prove the statement before evidence is given of the statement. It is proposed to prove a statement about a relevant fact by a person alleged to be dead, which statement is relevant under section 32. The fact that the person is dead must be proved by the person proposing to prove the statement before evidence is given of that statement. So dying declaration हो या 32 clause 4, the same rule will be apply everywhere. उसी तरीके से B में it is proposed to prove by a copy the contents of a document said to be lost. The fact that the original is lost must be proved by the person proposing to produce the copy before the copy is produced. So copy produce करने के पहले आपको ये prove करना पड़ेगा the original is lost. So that we have already seen in section 104 also. Now let's see the third paragraph. If the relevancy of one alleged fact depends upon another alleged fact being first proved, the judge may, in his discretion, either permit evidence of the first fact to be given before the second fact is proved, or require evidence to be given of the second fact before evidence is given to the first fact. अब इस वाले पैराग्राफ में और सेकंड वाले थर्ड और सेकंड पैराग्राफ में ज़्यादा डिफरेंस दिखेगा नहीं आपको. In this also they are talking about two facts. In this also they are talking about two facts. First paragraph is the general rule. How the fact is relevant be proven. How the fact is relevant is be proven in the first para. But the second and third para are talking about the situations where one fact is relevant only if some other fact exists. Second and third paragraph are talking about those situations wherein one part is relevant only if some other fact exists. And the difference between the second and third is that in that particular suit or proceeding, so second and third paragraph उस situations के बारे में बात करता है wherein one part is relevant only if some other fact exists. और जो difference है second para और third paragraph में, that in a particular suit or proceeding, in the second para only one fact is relevant and the other is not relevant, but the other's existence is important to make the other fact relevant. दो facts हैं, एक relevant है और एक irrelevant नहीं है, लेकिन जो relevant है वो relevant तभी होगा जब दूसरे वाला fact exist करेगा. और थर्ड पैरा में भी दो फैक्ट्स हैं, थर्ड पैरा में भी दो फैक्ट्स हैं और थर्ड पैराग्राफ में एक रेलिवेंट है क्योंकि दूसरा एग्जिस्ट करता है और दूसरा जो है वो खुद में भी रेलिवेंट है. दैट इज द डिफरेंस. सेकंड पैरा में दोनों फैक्ट्स रेलिवेंट नहीं है, एक फैक्ट रेलिवेंट है दूसरा रेलिवेंट नहीं है, लेकिन उसका एग्जिस्ट करना जरूरी है तभी पहला वाला रेलिवेंट होगा. थर्ड पैरा में वन पार्ट रेलिवेंसी डिपेंड अपॉन द अदर फैक्ट, बट द अदर फैक्ट इन इटसेल्फ इज आल्सो रेलिवेंट. कहते हैं ना alleged fact in that self is also relevant. थर्ड पैरा once again पढ़ते हैं हम. If the relevancy of one alleged fact means what? That fact sought to be proved in that case. Alleged means what? That you are declaring that this fact is also important and I want to prove in the case. If the relevancy of one alleged fact depends upon the another alleged fact, मतलब दूसरा जो alleged fact है जिसकी वजह से पहला वाला fact relevant है, उस केस में जो दूसरा वाला fact है खुद वो भी alleged है, मतलब दूसरा वाला fact भी एक relevant fact है. In the second para, one is relevant but the other fact is not. In the third para, both of them are relevant and the relevancy is one of them is depend upon the existence of the other. If the relevancy of one alleged fact depends upon another alleged fact being first proved, the judge may in his discretion either permit evidence of the first fact to be given before the second fact is proved or require evidence to be given of the second fact before evidence is given of the first fact. So write it down. The difference between the second and third para lies in the fact that in the second para only one fact is required to be relevant and its relevancy would depend upon the existence of some other fact. That other fact need not be relevant. However, in the third para, there are two facts and both of them are relevant. In the case, however, in the third para, there are two facts and both of them are relevant in the case. But the relevancy of one of them depends upon the existence of the other fact. In such a case, the court has a discretion to allow the proof of either of the fact first. तो कोर्ट की मर्जी है, दोनों में से आपको कोई भी अलाउ कर देगा. और जबकि सेकंड पैराग्राफ में आपको कोर्ट ऐसे अलाउ नहीं करेगा, पहले आपको अंडरटेकिंग देना पड़ेगा, जबकि थर्ड पैराग्राफ में अंडरटेकिंग की बात नहीं कर रहे. इन द सेकंड पैरा यू हैव टू गिव द अंडरटेकिंग, बट इन थर्ड पैरा अंडरटेकिंग इज नॉट रिक्वायर्ड. द कोर्ट विल सिंपली अलाउ टू प्रूव एदर ऑफ देम. आप ओरली कोर्ट में कह सकते हो कि पहले मुझको ये प्रूफ करने दो और कोर्ट आपको सिंपली अलाउ कर सकता है. And normally in this case the court is liberal also. Now let's see the illustration C. इलिस्ट्रेशन सी जाने से पहले एक टर्म बताता हूँ, दैट फैक्टा प्रोबेंस, PROBANS, फैक्टा प्रोबेंस इज द रिलेवेंट फैक्ट और फैक्टा प्रोबेंसिया। फैक्टा प्रोबेंसिया को फैक्टा प्रोबेंस कहते हैं और रेलिवेंट फैक्ट कहते हैं। लेट्स सी द illustration C. A is accused of receiving the stolen property knowing it to have been stolen. It is proposed to prove that he denied the possession of the property. The relevancy of the denial depends on the identity of the property. The court may, in its discretion, either require the property to be identified before the denial of the possession is proved, or permit the denial of the possession to be proved before the property is identified. अब suppose कोई मोबाइल फ़ोन है मेरे पास और that is not my mobile phone, and there is an allegation that I have received the stolen property from someone. किसी ने चोरी की थी और मैंने ये जानते हुए कि ये चोरी का सामान है मैंने उससे लिया है. And when I was arrested, I was asked that suppose the phone is iPhone 6, and it was asked to me that do you have Apple iPhone 6 with you when I was arrested of white color, and I say no I do not have. पुलिस ऑफिसर ने पूछा तुम्हारे पास iPhone 6 है वाइट कलर का, मैंने कहा नहीं, और जब उसने मेरी तलाशी ली तो मेरे पॉकेट से i6 मिला. अब why should I have told no when he have asked me? मैंने उससे मना किया और and it was found in my pocket only. A fact on the matter is that the charge against me is 411 IPC, that is receiving stolen property, and this conduct of denying the possession of phone is relevant in section 8. But my conduct of denying this phone with me will be relevant when the phone is a stolen property. अब मान लो ये प्रूव हो जाए कि ये मेरी प्रॉपर्टी है तो फिर तो चार्ज फेल हो जाएगा. अब हो सकता है मैंने घबराहट में बोल दिया कि ये मेरा फ़ोन नहीं है, मेरे पास कोई फ़ोन नहीं है. हो सकता है मैंने सोचा हो कि पुलिस वाला मुझसे छीन लेगा, इस वजह से बोल दिया कि मेरे पास फ़ोन नहीं है. या फिर मैंने किसी से कहानी सुनी कि पुलिस के भेष में आजकल लुटेरे घूम रहे हैं, तो इस वजह से सोचकर मैंने बोल दिया कि मेरे पास कोई आईफोन नहीं है. लेकिन सपोज इफ़ इट इज़ a stolen property and then I have denied, then there are two facts. One, my conduct of denying of the existence of the iPhone, and number two, the fact that the iPhone is actually a stolen property. So my conduct of denying the possession of the iPhone will be relevant only if it is proved that this was a stolen property. So stolen property wala part, the stolen property is one fact and my conduct of denying the possession is another fact. But my conduct of denying the possession is relevant only if the other fact, that is it is a stolen property, is proved. So now that is what they are saying here. The court may require you to prove the identity of this property, to prove the identity of the property stolen first, or the court may allow you to prove the conduct first and then later on allowed to prove that it is a stolen property. अब मान लो बाय चांस ये प्रूव हो जाए बाद में कि that property is not a stolen property, then my conduct is irrelevant. Then how my conduct is relevant? Because if I am having mobile, it is my mobile, and I am having the right to tell anyone that I am not having the mobile. So that is where this conduct of mine becomes relevant. So इस पे लिख लीजिए illustration C पे, the conduct of the accused in denying the possession of the mobile phone will be a relevant fact only if it is proved that the said property was a stolen property. Both these facts, which fact? The conduct of denial and the property is stolen property. Both these facts are relevant fact, but the relevancy both these facts are relevant facts, but the relevancy of the conduct depends upon the identity of the property. Identity of the property. Here, the court has a discretion to require the identity to be proved first and then the conduct or it may be the opposite. So it is upon the court कि वो क्या किसको प्रूव करना पहले अलाउ करे या बोले. Now let's see the illustration D. वो भी इसी से रिलेटेड लेकिन ABCD करके लिखा है. It is proposed to prove a fact A. It is proposed to prove a fact A which is said to have been the cause or effect of fact in issue. There are several intermediate facts B, C and D. There are several intermediate facts B, C and D which must be shown to exist before the fact A can be regarded as cause or effect of the fact in issue. The court may be either permit A to be proved before B, C or D is proved, or may require proof of B, C and D before permitting the proof of A. अब A किसी फैक्ट इन इशू का काउज है. A उस फैक्ट इन इशू का काउज तभी माना जाएगा जब फैक्ट नंबर B, C और D प्रूव हो जाएंगे. मतलब A रेलिवेंट कब होगा? When the cause of fact in issue, and cause is relevant in section 7. A is relevant under cause of fact in issue only when fact B, C and D is proved, and B, C and D are in themselves are relevant fact. तब पैरा 3 लगेगा, and if B, C, D are not relevant तब पैरा 2 लगेगा. If other fact is relevant then para 3. If other fact is not relevant then para 2. And presuming here that B, C, D are relevant fact, then in that case the court will require either to prove B, C and D first and then you will go for proving fact A, or you prove fact A first and then you will go for proving the fact B, C and D. So that's it with this illustration, this topic and this lecture. Thank you for watching this lecture.